Okay, Chapter 21, Part 3. Now we're picking up with some other laws that deal with employment discrimination. And another law is the Age Discrimination and Employment Act. And this law protects people who are discriminated on the basis of age if they are of the age of 40 or older. It also prohibits mandatory retirement for managerial workers and protects federal and private sector employees from retaliation based on age-related complaints. Editorial comments here. Number one, I think that this is probably one of the areas that's most difficult to prove. It also seems to be one of the areas that the EEOC and the courts are less inclined to want to deal with. Procedures under this law: the plaintiff must show that the discrimination was the reason for adverse employment action and establish but-for causation. That's a very high standard. In other words, if there was reasons other than the age of the employee, you lose. Okay? To establish the elements of a case, you have to show that you're a member of the protected age group, that you're 40 or older, you're qualified for the position from which you were discharged, and your discharge was because of age discrimination. If the employer offers a legitimate reason for its action, then the ball bounces back to the employee plaintiff to show that the stated reason is only a pretext and that the plaintiff's age was the real reason for the employer's decision. I think you can see from these rules why I said it's a difficult case to prove. What about replacing older workers with younger workers? The plaintiff must prove that the discharge was motivated by age bias. The replacement worker need only be younger than the plaintiff, and the greater the age gap, the more likely the plaintiff will succeed in showing age discrimination. State employees are not covered. They're immune based upon the Supreme Court's interpretation of the 11th Amendment. Moving on to another law. The Americans with Disabilities Act, the ADA. Okay, in my opinion, this has been one of the laws that one can point to if you want to argue that the government can make positive changes within our culture by an enactment of laws. And if you don't believe that, then take a look at a few very simple things. Walk down a sidewalk, come to the end of the sidewalk, and see the cut in the sidewalk, which allows wheelchairs to go down without having to go over the edge and fall over. Go into an elevator. For those of you who don't remember, the buttons for the floors on elevators used to be out of the reach for people who were in wheelchairs or for people who were small. Now, because of the ADA, all of those things have changed. Travel around the world and see countries that don't have an act or laws similar to the ADA, and you'll see what a difference it's made in terms of accessibility for handicapped individuals and others to be able to lead a normal life, work, etc. Okay, so one of the requirements of the ADA is it requires employers to offer reasonable accommodation to employees or applicants with a disability who are otherwise qualified for the job they hold or seek. Okay, the law itself, the statute, uses terminology that the courts love to use: reasonable. And of course, reasonable is not always that easy to define. Okay, so the elements and what a plaintiff has to show in order to sue and seek remedies is that you have a disability, that you're otherwise qualified for the employment in question, and that you were excluded from the employment solely because of the disability. and you have many of the same remedies as we talked about under Title VII. So one of the first issues you run up against in this area is what is a disability? It's defined as physical or mental impairment that substantially limits one or more major life activities. Life activities are usually walking, dressing, eating. Those are some of life activities. You have to have a record of such impairment or having been regarded by others as having that impairment. Some of the health conditions that have been considered disabilities under federal law include alcoholism, AIDS, blindness, cancer, cerebral palsy, diabetes, heart disease, muscular dystrophy, paraplegia, HIV positive, and morbid obesity. There are separate provisions under the ADA that prevent employers from taking adverse actions based upon stereotypes or assumptions about individuals who associate with people who have disabilities. Okay, so with regard to what's a disability, we look at mitigating measures, and in the past the courts focused on whether a person had a disability after the use of corrective devices or medication. So in other words, if you were in a wheelchair, if you were unable to walk, but you had a corrective device like a wheelchair that gave you mobility, could you perform the job? And if you could, then the employer could not discriminate against you. Today, the ADA as amended prohibits employers from considering mitigating measures when determining if an individual has a disability. And disability is determined on a case-by-case basis. Employers, of course, we talked about HIPAA and related laws and ADA and the ADA. Employers are required to keep their employees' medical condition and medical information confidential. If they disclose it, you have a right to sue, even if the employee was not technically disabled. It also applies to other people who act on the employer's behalf. Okay, reasonable accommodation. This is sort of an affirmative requirement for employers who are dealing with people who have a legitimate disability under the ADA. If an employee with a disability can perform the job with reasonable accommodation without undue hardship on the employer, the accommodation must be made. Okay? So, if you don't accommodate the disability, you have to show an undue hardship, and this is determined on a case-by-case basis. Okay? I don't know if we have a slide here, but generally the courts apply a weighing test. They look at the size of the employer in terms of determining whether or not the accommodation is reasonable. So if the employer only has 3 employees, then it's less likely that an accommodation that costs more or is less practical is going to be required under the ADA. On the other hand, if you're a huge employer with 2,000 employees, then you're going to have to do more than the employer with only 3 employees. Employers must modify applications and selection process so as to meet those people with disabilities. So obviously if somebody is deaf, you may have to provide an interpreter as one example. There are limitations on pre-hiring questions and physical exams. The employer can disqualify the applicant only if the medical problems discovered during the pre-employment physical would make it impossible for the applicant to perform the job. In addition, workers who with disabilities have to have equal access to any health insurance provided to other employees and cannot be excluded from coverage. So such a plan would violate the ADA and probably other laws unless the employer can show a business necessity defense. Okay, what about reasonable accommodation for drug addicts, substance abusers? It only applies to former drug users who have completed or are going through supervised drug rehabilitation. So in that situation, employers can fire or refuse to hire a person who is an alcoholic or a drug addict if the person poses a substantial risk of harm to himself or others, and the risk cannot be reduced by reasonable accommodation. Another law that protects employees is the Uniformed Services Employment and Reemployment Rights Act. It protects civilian job rights and benefits for members of the military, former military personnel, and reservists. It also provides additional protection for veterans who are disabled. It prohibits discrimination against persons who have served in the military. It has broad application and provisions. It covers all employers, both public and private, and applies to U.S. employers operating in foreign countries. These plaintiffs can sue the employer and the individual employees who were acting in the official capacity for the employer. They are personally liable. There's no statute of limitations. And veterans can only be terminated for cause. So the prima facie case, or the elements of the plaintiff's case, the plaintiff must establish that an employer's adverse employment action was based, in part, on the employee's military connection. And that military connection can be through the plaintiff's membership, service, or application for service, or it may be through testimony or statements about military service of another. If another similarly situated person with no military connection was treated more favorably than the plaintiff, the employer has violated the law. Under this law, returning service members are to be reemployed in the jobs that they would have attained had they not been absent from military service. Your remedies are damages, possible reinstatement, and or a promotion. So that ends part 4 of chapter 21. Again, the magic phrase is Title 7.